1 and 2.
Please, madam. I am there
Yes.
for the appellant.
Yes. Mr. Singh,
Please, madam.
during the course of argument, you have submitted the e-copy of the sale
Yes,
deed,
madam.
but
Yes, madam.
you have not enclosed the section 65B
The
certificate.
65B.
Yes.
But we will do it if my lords may grant us 1 week's time. We will do the needful.
Okay. Okay.
So grant us just 1 week, and we will file that affidavit.
Okay. Heard Mr. A. Singh, learned counsel for the appellant, and Mr. Majumdar for the respondent. Mr. Singh, learned counsel for the appellant in RFA number 73 of 2019.
Yes.
And respondent in RFA number 111 of 2019 submits that he may be granted 1 week time to file the section 65B of the Evidence Act certificate before this court by way of an additional affidavit. Fair allowed, list the matter on cover, fix that.
31st.
Grateful.
31st of July.
I'm so grateful.
Item 4 motion. Item 4.
None appears for the petitioner on call. List the matter after a week. In the event of subsequent non-representation, appropriate order shall follow.
Item 5.
Lordship, wife petitioner already filed maintenance proceeding, Lordship. Kindly turn into page 24.
This petition is filed by wife.
Wife petitioner.
Where she has been residing now?
Nagaon, Lord.
Nagaon. Then where the case is instituted?
This maintenance proceeding is pending at Nagaon, Lordship. And husband is also contesting this maintenance proceeding. Along with minor daughter, the present petitioner filed this maintenance proceeding. What happened, Lordship? Husband also filed divorce proceeding. If your Lordship kindly turn into page 8.
No, where the divorce proceeding is filed?
At Golaghat, Lordship.
Golaghat.
Yes, Lordship.
What is the distance between Golaghat and Nagaon?
Almost 165, Lordship.
Yes. How much time it takes?
165
How much time it takes?
3-4 hours almost, Lordship.
4 hours. So what is the difficulty?
No, wife, Lordship, totally incomeless, Lordship. Husband totally stopped to pay amount. Somehow she is maintaining her daughter, minor daughter, educational expenses and other expenses on.
In which paragraph of your petition you have mentioned that you are incomeless?
Lordship, if you are, Lordship, kindly peruse paragraph 5 at page 4. From 4th line, Lordship. Last maintenance amount paid at February 50,000, and thereafter respondent completely stopped paying maintenance. Consequently, since then, the petitioner has been facing extreme financial hardship to maintain herself and her minor daughter. And husband also resides at
where, in which paragraph you have stated that you have no income?
I'm incomeless. Lordship. Paragraph 6, Lordship. Married, Lordship.
Yes.
The respondent is a man of sufficient means and is the doctor, the director of 2 NGOs at Gauhati and Golaghat with substantial monthly income. The petitioner, on the other hand, has no independent source of income after losing her previous job and now entirely dependent on the support of her parents. The petitioner is finding it difficult to maintain herself and her daughter.
Okay. Okay. Heard Mr. Ardali, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure. Read it, article 227 of the. Oh, why 227?
Not 227, Lordship. If I am not mistaken, it is under 24 of CPC.
You are not mistaken.
24, let's say. Section 24 of Code of Civil Procedure, read with Article 227. Read with, Lord, sir. Otherwise, petition basically under Section 24.
You file amended cause title. Transfer petition under Article 227.
It is in at first,
Heard
let's say,
Mr. Arali, learned counsel for the petitioner. Leaves the matter on Monday. In the meantime, Mr. Ali, learned counsel for the petitioner, shall file amended cause title.
Hurry.
Item 6.
Malas, I missed out item 4. I was on leg number 2, quote number 2, Malas on leg.
After 1 week.
Item 6.
May it please your lordship,
Yes.
this is a transfer petition filed by the petitioner wife. Now I'm a resident of Hojai. Currently, I'm staying there with my bua. And after the marriage, I shifted to Dibrugarh, where my husband's permanent residence is located. We got married on 12/2/2029. We got separated on 8/10/2025. For 16 years, we stayed married, your lordship. The respondent has filed,
No, where the proceeding is pending?
the proceeding is pending in Dibrugarh.
Dibrugarh.
The rest.
Now you want to get it transferred to
Hojai.
Hojai. Pardon me, your name please?
S. Nisha Sultana.
Learned counsel for the petitioner. This petition under Section 24 of the Code of Civil Procedure is preferred by the petitioner for transferring title suit D number 27 of 2026 pending before the Court of Learned Additional District Judge Dibrugarh to the Court of Learned District and Session Judge Hojai. The learned counsel for the petitioner submits that the petitioner is the wife of the respondent and they got married in the year.
Your lordship.
They got married in the year
2009.
2009 and thereafter marital discord surfaced between them in the year 2025.
Yes.
And since then she has been residing at her parental abode at Hojai. The learned counsel for the petitioner further submits that the respondent herein has instituted one proceeding being title suit D number 27 of 2026 under section 13(1) within bracket 1 IA and IB of the Hindu Marriage Act before the Court of Learned Additional District Judge Dibrugarh. And since the petitioner is residing at Hojai, it is not possible on her part to contest the aforementioned proceeding at Dibrugarh. And under such circumstances, she has contented to transfer title suit D number 27 of 2026 to the Court of Learned District Judge Hojai from the Court of Learned Additional District Judge Dibrugarh. The submission of learned counsel for the petitioner needs further consideration. That this is this notice be issued to the respondent returnable in 4 weeks to be taken by state laws and also by usual process which will never come today. Lays the matter after 4 weeks. Is there any interim pair?
Yes, your lordship.
What is this? The proceeding is pending there.
Yes, your lordship. Your lordship.
What is this? The proceeding is pending there.
Appearance stage, your lordship.
Appearance. And considering the facts and circumstances on the record and also the submission of learned counsel for the petitioner, further proceeding of titles of D number 27 of 2026 pending before the Court of Learned Additional District Judge Dibrugarh stands state till returnable date list after 4 weeks.
That's your lordship.
Item 7.
This case, my lord, an ex parte proceeding lordship application for amendment was, my lord, mob lordship, 36, the impugned order lordship. The affidavit was not there, my lord, that is why, my lord, the petition was rejected, Lordship. That's 36. My Lord, paragraph 4. As no affidavit is filed, petition stands rejected. This is a curable defect, Lordship.
Your petition for amendment was rejected.
Yes, Lord. Because, my Lord, affidavit was not filed, Lord. This is a curable
At,
defect, Lordship.
what is this? The case is pending.
Sorry, Lordship.
At what is this? That proceeding is pending.
Argument stage, Lordship. Argument stage, Lordship.
Whether in argument stage amendment can be allowed?
My Lord, if despite having due diligence, my Lord, that clause is satisfied, Lordship.
Hmm.
It can be filed when
And why the trial court has dismissed your petition?
this is only because, Lordship, affidavit was not filed, Lord. My Lord, other ground was not there.
Affidavit means?
Page 36, Lordship. Affidavit is not there, Lordship. There's 36, Annex 4, Lordship. Paragraph 4.
No, is it not necessary to file an affidavit in
My Lord,
support
it
of the
is
petition?
necessary, Lordship. It is curable defect. We could have, the plaintiff could have been, my Lord, given opportunity to, my Lord, file affidavit, Lordship. That was not given. Straight away it was rejected, Lordship.
Curable defect, where it is mentioned?
My Lord, in the application, my Lord, it is not stated it is curable defect, but it is stated before.
No, you were submitting that it is a curable defect.
Yes, Lord.
On what basis you were submitting?
My Lord, the affidavit, my Lord, this is, my Lord, the Honorable Supreme Court in many cases, Lordship, stated, my Lord, the
Can you?
procedural defect. My Lord, I have taken some judgment, Lordship, my Lord. My Lord, facts, my Lord, I could not go to the facts, my Lord. Day after tomorrow, my Lord, it may be fixed, Lordship.
Not day after tomorrow, on Monday.
Lordship.
Heard Mr. M.A. Ahmed, learned counsel for the petitioner. This petition under Article 227, read with Section 151 of the Code of Civil Procedure is preferred by the applicant. 4. No, challenging the order dated 23rd April 2026 passed by the learned civil judge in petition number 746A stroke 2026 arising out of title suit number 128 of 2024. Mr. Ahmed, learned counsel for the petitioner, submits that the petitioner herein filed an amendment petition, filed an application for amendment of the plaint, but the same was dismissed by the order dated 23rd for 2026 on the ground that no affidavit was filed with the petition. Mr. Ahmed submits that it is a curable defect and there are several decisions of the Honorable Supreme Court on this point. 10. He prays for granting him time to produce the decision of Supreme Court before this court. Fair allowed, raises at least the matter on Monday.
All right. Monday may be, my Lord.
Wednesday.
My Lord, case is 29th, my Lord, it is fixed for argument here. Before that, may be.
27. Okay.
Obliged. Monday, isn't it?
Lakshmi,
No, these are maybe same as yesterday's. If they come up on Monday, along with the other cases. Last, what is the number?
Okay.
Yes. Yesterday's
103.
103 of 1000.
Monday.
On that day,
On that day,
Monday,
2 p.m.
Whatever, I have no issue. I have no issues.
heard. Nice. M. Hazurika,
No.
learned senior counsel assisted by Mr. Khan, learned counsel for the petitioner, and Mr. Gogoi, learned CVC for the respondent number 1, 2, 3,
Lordship.
and Mr. Gogoi for respondent number 4, and Madam for respondent number 5. 5. Raises a list this petition along with,
Lordship,
what is the number?
I don't know, without taking it, otherwise individual cases, that also is individual. So my lord may fix it on 27, Lordship, without taking the matters, Lordship.
Why not? All the same matters. We'll take up one by one, Lordship.
If it is taken, it should be passed a common order. So Lordship may fix it.
Not necessary. Why different dates?
Different, I'm not saying different dates. My Lord may fix it on 27 Lordship without taking the matter. And because all the title suits are defined Lordship.
No, I am not directing to take this matter.
Lordship may fix it on 27.
Along with, along the series.
Along with the other
Yes,
matter.
along with the
Along with
others.
does not mean that I am taking the matter with that
Along with
matter.
others.
Yes. What is the number of that yesterday's? petition?
103 of 2026.
Pardon?
103.
Okay.
103.
Okay. And till then, the eviction proceeding should not be initiated against them.
My Lord,
Lovely.
fix it at 2 PM Lordship.
Recessal is the
As
matter.
per Lordship's convenience. I have no.
31, I number 12 and 27.
Lordship, item number 11, 13 and 15, we have not received copy Lordship. 11, 13 and 15.
Okay, Mr. Khan, furnish a copy to them.
27 we have not received. Lordship.
27 also.
Yeah, some also not been instructed in the policy.
GA. Okay.
Yes, sir, but yes, Asama party.
Mr. Gogoi has pointed, you give the number to the court master. We will reflect it in the order. Recessal reflect the name of Mr. Gogoi in the cost letter. No, sorry, in the court list.
11, 13, 15.
You have seen the thing. তাতে আছে না, super.
বাইদেউ ৰিচিভ কৰা গৈছে কিন্তু কপি আমাক দিয়া নাই। ভাল হিচাপত পিটিশ্যন লৈ গৈছে
Number 30.
You only check নকৰে তোমালোকৰ।
সেইটো কৰা হৈছে ৰেজিষ্টাৰতে দিয়া আছে।
Timing for that.
Item 4, orders, item 37. Order matter.
Matter may be passed over for time being.
Okay, timing.
Item 38.
Would have received the copy, my lord. I'm going to file a wakalatnama for the respondent for the date. madam.
None appears for the appellant on call. How Ms. P. Bora, learned counsel, entered appearance for respondent number?
All the responses.
Oh, all the respondent. And she submits that she will be filing her power today during the course of the day. Lays the matter after 1 week. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Item 39.
I'm appealing for all the respondents.
Your lordship, my senior is on the way. We have taken steps to, your lordship may pursue the office order, office note.
You are appearing for 5A, 5C also.
Yes.
Okay.
Already in fact.
Heard, miss, your name, please?
Timor.
Learned counsel for the petitioner. And also heard, Mr.
T.
Roy, learned counsel for all the respondents.
Yes.
All the respondents. Since service in this matter is completed, recessal is the matter for admission. On copy fixed date, this is 14 matter, 2014.
12 August.
Last part of August.
Last part.
26.
Much worse.
Much.
Item number 14.
My lord, in this case, I have submitted one IF for substitution of legal years of respondent number 2, your lordship.
When?
Yes. That is not, I have checked a little earlier, that is not number, your lordship, that is not registered.
Today you have filed.
No, my lord. On 13th day of July.
13th of July you have filed.
My lord,
It has not yet been registered.
my lord. I have to verify, your lordship.
Okay. Heard, Mr. Rahman, learned counsel for the appellant. None appears for the respondent on call. Mr. Rahman submits that he has filed one interlocutory application for bringing on record the legal representative of respondent number 2. Respondent number
2.
Respondent number 2. Who suffered demise when?
My lord,
When he died?
died on 25/6, your lordship.
25,
25/6, 2026.
25/6, 2026.
Yeah.
Pair allowed or list the matter after 1 week.
My lord.
1 week. In the event of subsequent non-representation of the appellant, appropriate orders shall follow.
Yeah, please.
Service completed here.
I'm waiting on the respondent.
How many respondents are
There's
there?
only one respondent.
One. Okay. Heard, Mr. Your name, please.
N. Patiri.
And Patiri, learned counsel for the petitioner, and Mr.
Lordship, it's a matrimonial matter may be disposed itself, if possible, Lordship.
Today.
Yes, Lordship, if possible, because they want to challenge.
The written statement, my lord, especially the written statement, my lord, in case of the defendant, my lord.
But what is this, Lordship? It is a in final stage.
My lord, let the trial court decide that, my lord. My only prayer is that because a similar thing was done again by the trial court. Earlier, it was same order passed. Next day also, when the your lordship had remanded back the matter, the similar thing was done. There was no application of judicial mind, my lord. There was only thing is that there is a, my lord, I'm very sorry to say, but with due respect, my lord, it's a cut copy paste order, my lord. Let me hear me again, my lord. I'll explain my delay. If there is no amendment, then let the trial court reject on that thing. One opportunity, my lord. Let me go into the fact, my lord. This is important, my lord.
No, Mr. Patiri, you say, in order to remand the matter to the trial court, we have to set aside the impugn order.
My lord.
And to set aside the impugn order, you have to show sufficient reason.
And only in the delay part, I had filed the application for recalling of witness immediately, my lord. But on the next date, I had filed the amendment application, my lord. That is the only lapse, but there is no explanation with that regard.
Okay, you do one thing, you produce the decision of the Supreme Court that in respect of amendment of the written statement, leniency can be taken.
My lord, I have with me, my lord.
What do you say?
Copy number citation to. Hello, sir, paragraph 21. Hello, sir. Citation is 2007. My lord, if I may read. Paragraph 21, my lord. Such being the settled law, we must hold that in the case of amendment of a written statement, the courts are more liberal in allowing an amendment than that of a plain, as the question of prejudice would be far less in the former than in the later case. Later case. Even in the decision relied on by the plaintiff in Modi's pleading, clearly recognizes that inconsistent pleas can be taken in the pleading. In this context, we may also refer to the decision of so and so. In that case, the defendant had initially taken up the stand that he was a joint tenant along with others. Subsequently, he submitted that he was a licensee for monetary consideration who was deemed to be a tenant as per the provisions of 15A of the Bombay Rents, so and so. This court held the defendant could have validly taken such an inconsistent defense. While allowing the amendment of the written statement, this court observed him so and so as regards the first contention, we are afraid that the courts will have gone wrong in holding that it is not open to the defendant to amend his statement under Order 6, Rule 17 by taking a contrary stand that was stated originally in the written statement. This is opposed to the settled law open to a defendant to take even contrary stands or contradictory stands. The cause of action is not in any manner affected. That will apply only in a case of the plain being amended so as to introduce a new cause of action. Paragraph 22. As we have already noted herein earlier that in the allowing the amendment of the written statement, a liberal approach is a general view. When admittedly in the event of allowing the amendment, the other party can be compensated in money. Technicality of law should not be permitted to hamper the courts in the administration of justice between the parties. in the case of so and so, this court observed that the courts are more generous in allowing amendment of the written statements, as the question of prejudice is less likely to operate in that event. In that case, this court also held that the defendant has a right to take alternate plea in defense, which, however, is subject to an exception that by the proposed amendment, the other side should not be subjected to serious injustice. It's only the serious injustice. It can result only in some few days of delay, my lord. And also, my lord, I'm praying for your lordship superintendence over the matter, because, my lord, adultery has been alleged against me. The co-adulterer has been made a pro forma respondent, but he was never proceeded ex parte. He appeared, there was no trial against him, there was no evidence.
Service, the TCR was awaited. I believe, my lord, the TCR is here. So, my lord, the matter may be listed for hearing in its due course.
Okay. TCR has been received.
Yes, my lord.
Heard Mr. Mitra, learned counsel for the appellant. And also heard Mr. learned counsel for the respondent. It is submitted at the bar that in this matter service is completed and the TCR has also been received. And as such, the matter may be listed for hearing in due course. Accordingly, it is provided that recessor leaves the matter for hearing in usual course.
Obliged, my lord. May I please your lordship, my lord? My lord, this IA number 1975 of 26, my lord, we want to withdraw with permission to refile. My lord, what has happened is, in a review petition, the review petition was allowed, whereby a new document was allowed to be taken on record. But a formal application was directed
You
to be
want
filed.
to withdraw this IA?
We want to withdraw and refile it, my lords.
Okay. Heard Mr.
S. Murarka.
Learned counsel for the applicant. Mr. Muraka submits that he may be allowed to withdraw this application and to with a liberty to file a fresh one as some inadvertent mistake creeps in the in this interlocutory application pair allowed. This IA stands a disposal of withdrawal. However, liberty will remain with the applicant to approve this court again by filing appropriate application.
One more thing is there, my lord, in this matter, in the review petition, my lords, the respondent in the second appeal, he got expired. So his legal heirs were substituted. But now even in the second appeal, even the cause title has not been amended by the registry, my lords. We have a copy of the amended cause title, which may be allowed because already by order in the review petition, the LRs have been brought on record. Would my lords kindly see page 3 of that order in review, where the two LRs of the respondent in the second appeal has been substituted in the review. So there.
No. When you have filed the amended cause title.
No, my lords, what has happened is in the review they have amended it because there was a direction that you amend the cause title and these two people be brought on record. Now in the second appeal, the registry has now raised an objection saying that after the review has been allowed, the registry has mentioned that the legal has not been put on record in the second appeal. So, my lords, already there is an order for substitution. These same people have to be put on record in the second appeal also. Only the cause title, which was allowed to be amended because of the death of the respondent therein. We have given a copy of the
You
amended.
have filed your amended cause title in the RSA.
Lordship, after disposal of the RSA, we file a review application, and during the pendency of the review application, the
respondent died.
Review petitioner died, and that's why we brought on record the legal heirs, and that was allowed. So in the review cause title of the review petition, our name has been brought in, but after subsequent to allowing of the review, RSA has been restored. Now the cause title of RSA needs to be amended. That is the issue.
No, is to be amended. You have to file amended cause title.
We'll file it.
We'll file it before the registry manager.
When?
We'll file it today.
Today itself.
Today itself.
We have prepared a copy of that amended cause title, my lords.
The learned counsel for the appellant in RSA number 73. Okay, is it listed today? RSA?
Yes, my lords. Yes,
No,
my
no,
lord. It is
listed
shown in the
today.
cause list along with RSA.
Okay. In RSA number 73 of 2013, amended cause title has been filed today.
Today we will be filing.
We'll be
No,
filing, we have
that,
prepared it, my
amended
lord.
cause
Copy
title
has
will
been
be
handed over
filing
to your
today.
lordships, my lord.
In RSA number 73 of 2013. On such amendment, cause title being amended, cause title being filed, registry shall do the needful.
Much obliged, much obliged.
Filed by the appellant.
Lordship, item 38, non-appearance has been given, Lordship. Due to defect exam, I have just a
We
moment,
have,
within
we
a
have
moment.
given the date, you take the date. On that day, we'll take it.
Matter will go for hearing. That is one line of order will do. Otherwise, I'm frustrated, my lord.
Please, Lordship may kindly pass over the matter, Lordship. Answer for the forest within another court, Lordship, in case in another. Okay.
Number 50.
May please, Your Lordship. Kindly matter may be taken after some day. My senior is Lex. After this.
And 52.
Wait, please, your lordship, matter may we pass over for the time being, lordship.
There are 53.
In this case, my lord, respondents are appeared, my lord. But it is the matter for admission, my lord. Service already completed, completed, my lord. What the respondent appeared, my lord.
So service completed.
Completely.
We will list the matter for admission then. Heard Mr. Padgiri, learned counsel for the petitioner, Mr. Bhattacharya for all the respondents.
One and two. One and two.
One and two. Since service in this matter is completed, let's list the matter for admission. When?
After 2 weeks, after 2 weeks, my lord.
After 2 weeks.
My lord.
Okay. After 2 weeks.
But till the return, my lord, there is a interim order, my lord.
Interim order pass earlier shall continue.
My lord. Obliged.
54.
For the sole respondent, Lordship. For the already. It was mentioned matter of thought it may be given. Because
None appears for the petitioner in call. However, Mr. Sharma, learned counsel for the respondent present. List the matter after a week.
after you, yes, Lordship.
In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Yes, Lordship, obliged.
Item 55.
May I please, Your Lordship?
Hmm.
Lordship, here I have entered the petitions for the respondent, Lordship. Yesterday I filed my no, Lordship. I need to file an objection here. Because they have already withdrawn that RSA and now they are coming for restoring that RSA, Lordship. 2 years back they have withdrawn, Lordship.
But where are the parties now?
Now they are not there, Lordship.
None appears for the applicant on call.
It's time, Lordship, to file.
However, Mr. Your name, please?
M. Ahmed, Lordship.
M. Ahmed, learned counsel for the opposite party present. And he pressed for granting him 1 week time.
2 week time, Lordship.
2 weeks time to file his objection. They are allowed. List the matter after 2 weeks. In the event of subsequent non-representation of the applicant, appropriate order shall follow.
I am approved, Lordship.
Present for hearing under order 41. Because 34 and 35.
Wait, this is 52, 53, 54 completed. Okay, okay.
You're
So,
not the respondents.
okay. Appellants are absent today. None appears for the appellant on call. However, Mr. N. Hock, learned counsel for the respondent present. List the matter after a week. In the event of subsequent non-representation of the appellant, appropriate order shall follow. After 1 week.
56. Sorry, 35.
Other side or নাম show করেছেন কি? Lordship. Mid page, your lordship. This regular second appeal has been filed by defendant number 1, lordship. Other side or নাম আছে? In this case, already.
The
notice
other
was-
day, Mr. Arsama
Respondent-
appeared.
Lordship, Arsama was absent other day also and today also, lordship.
Let
As
it
they-
be after some time, he will contact the council.
Lordship.
Item 48 for admission.
36. Look at my. 36 also. No, 36 to hearing. Order 41 will come.
May please, Lordship.
Yes.
Lordship, kindly pass over the matter for time being.
Time being.
Lordship.
Item 36.
Lordship, pass the matter for time being.
Okay.
For hearing 47.
You go for the respondent.
Yes, Lord.
None appears for the appellant on call. However, Miss Odhikari. Your name? Pardon? P. Odhikari, learned counsel for the respondent present. List the matter after a week. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Pending items. Item number 32.
May it please your lordship. My lord, on the last occasion, your lordship posted the matters we did for consideration about the maintainability of the writ petition under my lord, petition under 227. That is the issue. Now, my lord, this is a commercial suit filed by the respondent herein, and an injunction was obtained. And against that, my lord, we have come before your lordship under 227.
Now, our primary grounds were that, my lord, the court exercise jurisdiction not vested in it, and also, my lord, beyond its jurisdiction. On 3 points, my lord, primarily we came. Firstly, my lord, Commercial Courts Act require, my lord, section 12A, if your lordship takes up the Commercial Courts Act. Section 12A. That
Yes.
is, my lord, 6 perhaps. 12A, pre-litigation mediation and settlement. A suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts the remedy of pre-litigation mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. So, my lord, the first thing that needs to be considered is, my lord, whether any urgent, my lord, relief is contemplated. Here was a case, my lord, I'll show from the, my lord, the plaint itself that there was no urgency. And, my lord, the fact that, my lord, section 712A has to be, my lord, considered by the court, my lord, whether there was any contemplation and there was any urgent relief. That is, that has to be considered before, my lord, granting any injunction. There is no discussion on that. My lord, there are case laws, I'll, my lord, if necessary, please.
That's all right. Whether those grounds cannot be adjudicated in an appeal?
I am coming to that, my lord. I am coming to that. But, my lord, I'm, my lord, placing the grounds on which I came, my lord. That is one, my lord. And so far as the urgency is concerned.
Today we are only concerned with the maintainability of the petition.
Yes, my lord. My lord, my submission is that if the, my lord, court exercises jurisdiction not vested in it, then, my lord, your lordship may interfere under 227. And here is a case, my lord, the cause of action for the suit arose in Arunachal Pradesh, not here, my lord. We are the IOC, we supplied materials in, my lord, Arunachal Pradesh, and the suit was filed here. That is one jurisdictional error. Second jurisdictional error is that, my lord, beyond the jurisdiction, what was prayed for, the trial court granted more than that. My lord, these are only besides the point right now.
No, that's
I
all
have
right.
filed an additional affidavit.
Yes.
Your lordship may kindly take up the additional affidavit. Copy to in fact, in this additional affidavit, has it come?
Additional affidavit.
Hasn't it come? My lord, even if it doesn't come, your lordship might take it because I have only placed one division bench judgment. And, my lord, the notifications that have been referred to in the, my lord, in the judgment. Your lordship may kindly take up, because, my lord, these are not, there is no other argument, only, my lord, placing on record this judgment. And the notifications that have been referred to in the judgment. Your lordship will find the, my lord, judgment.
No, that judgment I have noticed in another petition.
My lord.
In another petition, I have taken note of the said notification.
My
No,
lord.
sorry, said order, division bench order.
My lord. So the division bench order says, my lord, as per this division bench order, my lord, there is no, my lord, there cannot be any commercial court. In the event, my lord, there is no commercial court, the commercial court has to, my lord, return the plaint, but to file as a, my lord, normal suit. Because there is no existence of, my lord, commercial court because of this judgment. In that event, my lord, the petition has to be returned. My lord, the plaint has to be returned. Because this judgment has clearly said, my lord, that the notification under which the government constituted the commercial courts, that is non-est. If that is non-est, the court is non-est. Because, my lord, the civil judge senior division is exercises jurisdiction under the, my lord, Commercial Courts Act. So, my lord, if an application is filed before, my lord, civil judge, under the, my lord, Commercial Courts Act, and when the court comes to know that the commercial court is not functioning, then, my lord, it has to return the plaint to present it as a normal suit. And this question I can agitate only under Article 227.
No, can this question cannot be adjudicated in an appeal?
My lord. My lord. Hmm? My lord, this order actually, my lord, after.
No, that's all right. The problem is that against that order, appeal is provided. And the principle is that when alternative remedy is provided in the CPC itself, the petition under Article 227 is not maintained.
No, my lord, that order is not passed under, my lord, in a normal suit.
Maybe same procedure is there.
My lord, in the event, my lord, I satisfy your lordship is satisfied that, my lord, the commercial code doesn't exist, that has a it has to be, my lord, the plaint has to be returned for presentation. Then we take all the grounds, my lord. They are before the, my lord, trial court. Because.
So is there no commercial court here?
No, my lord. As on date, my lord, there is no commercial court. There is no commercial appellate court. There is no commercial, my lord, division, even in the High Court, my lord, because of this judgment.
It may not be in the High Court, but
Because,
when
my
this
lord, if I have, my lord, coming to your lordship's, my lord, query, if I have to file an appeal, my lord, I have to file an appeal against the, my lord, commercial, my lord, commercial court's order in the, my lord, commercial appellate court. Commercial appellate court does not exist. As on today, it doesn't exist. Unless, my lord, the government comes up with a, my lord, clear notification constituting the commercial courts, I cannot, my lord, come on appeal also. Therefore, my humble submission before lordship is that, my lord, in view of this division bench judgment, which is, my lord, binding on your lordship, my lord, your lordship will have to, my lord, agree to the fact that, my lord, commercial court didn't exist. The power that has been exercised by the, my lord, civil judge in exercise of power under the Commercial Courts Act, that is not there, that is non-est. Therefore, my lord, the order is also non-est. And, my lord, I cannot file an appeal under the Commercial Courts Act because, my lord, the commercial appellate court does not exist. So, my lord, the only remedy available is, my lord, 227. In fact, my lord, against the issuance of notice, my lord, I filed an appeal before the, my lord, commercial appellate court. That, my lord, I have to withdraw that also, my lord. Subject to, my lord, what your lordship decide. My lord, this type of situation never arose before, man.
Okay, we will reserve the order. Or Mr. M.K. Soduri, learned counsel for the petitioner. Order reserved.
Okay.
Can we make a 37?
May it please your lordship. My lord, pursuant to your lordship's last order, 3/6/2026. My lord, a direction was given to the council for the State Bank of India to file an affidavit stating regarding the disbursement of that amount, my lord. Your lordship sees that order, your lordship will be clear. 3/6, last order, 3/6/2026.
Whether that affidavit has been filed?
No, my lord.
Then government side or today?
My lord, I am correct. Respond number E. So,
Who is for the government side?
1, 2, and 3.
Earlier, Mr. Deenath appeared.
My lord.
Respondent number? Heard,
My
Mr.
lord,
Yan.
I was sufficient, my lord. My lord, in view of the judgment given by our division bench, my lord, this leave petition is not mandatory, my lord. It is going to the Kala, and Kala will refer to the, my lord, original jurisdiction of the judgment. Similar setup there. Kindly show, my lord, para number. It is page number 9 of the last but one paragraph.
Okay, we will hear you.
Yes. Prima facie, which I have read, this issue was once also raised, this issue once came up before this court, earlier round of this issue, my lord.
Okay.
But the court said that dispute is not there because that compensation amount has already been determined. Whether if tomorrow, if the authority says that I am not entitled for 50 lakhs, that compensation amount, then it will be referred to an arbitrator. That process is there, but that disputed amount is not, that dispute is not there regarding that amount, 50 lakhs something amount. The only issue is there regarding payment.
No, dispute is on that matter because the treaty is in my favor. So it is dispute is very much there. So dispute cannot be decided by this court, my lord. So my humble submission in view
Okay,
of-
we will say,
my lord.
we will hear the parties on next day.
But it is the judgment is very clear. My lord, any dispute have to be referred to the court.
Heard, Mr.
K. Mohammed.
Learned counsel for the petitioner. Mr. Mohanto for respondent number
8.
Respondent number 8.
A Borua for respondent number 1, 2, and 3.
A Borua for respondent number 1, 2, and 3. And M does for respondent number 7. And respondent number 9. Learned counsel for the respondent numbers 9 submits that they will be filing the respondent number 9 will file the affidavit during the course of the day. Mr. Mohanto, learned counsel for the respondent number 8, is referring to a decision of a division bench of this court in WA number 299 of 2025 submits that dated 28/5 of 2026 submits that the present petition is not maintainable. The issue of maintainability of the petition will be taken up on next date. List the matter after 1 week.
That will be better from there on, because unless they spend time here.
We'll see how this judgment will help you.
Yes, but
Yes.
Timely item,
Obliged.
49. Timely item 50.
Again, they are not present. After some time then.
My senior is let's go to number 18 for hearing.
For how long?
Next week. Next week.
Next week.
Yes.
Okay. As agreed by learned advocates of both the parties, recess shall list the matter on. Public.
August first week. On 7th August.
Mass service.
Coming item 51, 52.
May I please, Your Lordship? Your Lordship, as per office note dated 21/7/26, TCR of TS has been received, Lordship, but TCR of title appeal has not been received yet. Service is already completed, Lordship.
Heard Ms. Hazarika, learned counsel for the appellant, Mr.
Park Ghosh.
Learned counsel for the respondent. Office note dated 21/7/2026 indicates that TCR of TS number 90 of 2012 has been received, but TCR of TA number 17 of 2021 has not been received. Accordingly, it is provided that recess shall issue urgent reminder to the learned court below for transmitting TA number 17 of 2021. List after 1 week or 2 weeks?
1 week, Lordship.
1 week. Covered. Next. In item number 52, it is
Tag matter, Lordship. Same matter, different parties, Lordship.
here record has been received, TCR has been received. TCR received. In name of the party same. Office note dated 21st of July 2026 indicates that LCR of TS number 90 of 2012 has been received, but LCR of TA number 17 of 2021 has not been received. Against the same judgment,
Yes, Lordship, but different parties, Lordship. Same matter.
recess shall issue urgent reminder to the learned trial court, no, learned first appellate court to transmit the record without further delay.
Yes.
My Lordship, I apologize with regard to item number 50. Yes.
No, the other counsel left, already left.
Yes, my Lordship, because hearing was going on. So
Okay. Okay.
Yes, my Lordship.
And for admission 48.
Lordship, if possible, kindly taken up the matter by Friday.
Okay, we'll call the matter again after some time.
Lordship.
And my lord, the ruling implemented person, my lord, I will like to file wakalatnama, my lord, against me.
When?
Sunday Kumar. My lord, I can file by next week.
Next week.
Next week.
Heard. Mr. Kolita, learned counsel for the petitioner. And Mr. Gogoi,
My lord,
learned counsel for the contender. Mr. Gogoi submits that within a period of 1 week, he will be filing the Ukalatnama. And he pressed for listing the matter after 1 week.
my lord,
List the matter on cover.
On 10th August.
my lord.
10th of August.
Lodge.
Kindly
As,
take it.
as part of Lordship.
As part of.
Lodge.
Alright.
All right.
Coming item 48 for admission. Order waiver.
Mad lordship.
Mm.
Lordship, first of all, I want to apologize for saying regard to delay.
All right.
The matter is pertaining is a provincial litigation. So hearing lordship already appreciate in this court lordship. So several times at the matter lordship. So the Juneshwari case lordship is on that way. So
The other side is absent. Kobe.
Actually, interest. Even translate. Any other day option if it's not available. Yeah, sure.
Oh, wait for some time. I have seen the council here.
Yes.
After some time.
Oh, yes. Awesome.
Termination 35 hours under 41.
May it please, your lordship. In this case, lordship, on last occasion also they did not appear. And moreover, lordship, for admission of regular second appeal, the presence of respondent may not be required, lordship. Though after issuance of notice, they filed their Okelotnama and on 2 occasions they did not appear. And my learned friend already called them, lordship, that the matter has been listed today. So
When?
Today, no, on that day. From the Wakalatnama, we have obtained the phone number and then contacted them and the matter was fixed
Okay.
today, lordship.
It is. Huh? I see. It may not be necessary, but the council was present in the morning today.
Lordship, it is their
So
duty to
can I
remain.
wait for some time?
Lordship, then at 2 p.m. Lordship.
At 2
That
p.m.
may be reflected in the notice board that at 2 p.m. this matter may be taken, Lordship.
No, before that also we will try. Wait for some time.
Lordship.
Because we have no matters to take it up at 2 o'clock.
Lordship. Oh.
Therefore,
So, Lordship, but Lordship, from the records, your Lordship will see their prayer was for some land and the prayer given by the trial court and the first appellate court more than that, Lordship. So, this is a case which is maybe your Lordship will be satisfied to admit, Lordship. And we have also stay petition also. So, Lordship, I am waiting for them for some time, Lordship.
okay,
If
for
they
some
pay.
time. We'll
Lordship, of that.
Then 48.
Lord, now he has come, my lord, but unfortunately now Mr. P. Gogoi is on elects in a different position. I think in court in order. My lord, what to do? It's for SSA, I'm for elementary. So, if we fix it at 2, otherwise some other day, my lord. The matter. Because what has happened is we were there in the other occasions, first half. Now Mr. Gogoi is on legs. He was not present that time. So,
Wait.
Lordship, if possible, Friday, Lordship. If possible, Lordship, Friday.
Will he be able to remain present at 2 p.m.?
Yes, my lord, he can be present.
Yes, 2 p.m.
Okay, 2 p.m.
2 p.m.
Yes. Master.
May it please your lordship, this appeal is by the defendant lordship against reversal. The trial court dismissed the suit and the first appellate court allowed the degrade the suit in favor of the plaintiff. Lordship, the suit was for declaration of right title interest, claiming that he as a brother, he is entitled to half, and our case is that my father has only 1 plot and my mother got 2 plots. Those 2 plots were given to him and this plot was given to me. And on the basis of that oral settlement, lordship, the trial court accepted our plea and that has allowed, lordship. The substantial question of law that we have framed, lordship, will find, lordship. It was oral settlement, so lordship. Under Muslim law, gift can be, lordship. The 3 things has to be satisfied. That is declaration, acceptance and possession. So I'm in possession, Lordship. And our cousin who is common cousin to both, he has given, they, both of them deposed that it was given to me,
Mr. Chakraborty,
Lordship.
this is second appeal
Second appeal, Lordship.
under section 100.
Lordship.
You see subsection 3 of section 100.
Yes, Lordship. Yes,
Where is your substantial question of law?
Lordship, it is in annex, Lordship.
Where?
After the Lordship index page.
No. What is the language of the subsection 3?
Yes, Lordship. In an appeal under this section, the memorandum appeal shall precisely state the substantial question of law involved in the appeal.
Where in the memo of appeal you have stated the substantial question of law?
Lordship, I have the next, Lordship, let me check it out, Lordship.
No, is it the meaning of the section?
Lordship, I have drafted this on this substantial question of law.
Mhm.
That's important.
You have to incorporate in the memo of appeal itself after the grounds and before the certificate. There is a decision of Supreme Court also on this point. That in memorandum of appeal,
Lordship, let me check
The
it. Draft,
appellant has
that
to-
draft substantial question of law has been annexed, Lordship.
that is not the meaning of the subsection 3 to section 100. Part, Mr. Chakraborty, learned counsel for the appellant. It appears that as required by subsection 3 to section 100 CPC, the substantial question of law has not been suggested in the memorandum of appeal. And in that view of the matter, the appellant is directed to file amended amended memo of appeal incorporating the suggested substantial question of law.
Lordship.
Place the matter after 1 week,
Lordship, 2 weeks, Lordship.
2 weeks, 2 weeks. Arcitas. 2 p.m. 2 p.m. 2 p.m. 2 p.m. Donated all.
35.
At 2 p.m.,
Lordship.
they've contracted with the council.
Lordship.
Someone will remain present.
Lordship. Obliged.
In the dice data for the academic year 2011, the name of the Rajiv Gandhi LP school is found with dice code showing, but the name of the teacher has been entered as some W Hawk instead of Mumtaz Begum. In the academic year 2011-12-13, the name of the Rajiv Gandhi LP school was found in dice data code number showing, and the names of the teachers were entered as Deepak Kendrick and Mumtaz Begum. During the 2013-14, in the dice data, name of Rajiv Gandhi LP school has not been found in the mentioned category, but the same, but the name of the school was found in the order of provincial rating issued by Ordinance 20 and has been withdrawn. So provincial dated 13th of May 13th, instead of Rajiv Gandhi LP school due to non-availability of dice code as per the office record of the director of education. So therefore, I want to ask now. And the inspection report also is here. What for the inspection report? Annex one at page 241, 252. The numbers also don't match one. But you know, only my senior friend developed in the affidavit filed by the SSA.
So Lordship, we do
And
respect.
they are main authority ballot. The DEU was on the main authority ballot. Regarding the dice code ballot, it is the SSA ballot was sole authority.
So Lordship, we do respect Lordship. So SSF had one affidavit Lordship. My friend Lanet Council raised this query Lordship. And find Lordship. Page 61 Lordship is a affidavit had by the SSF Lordship. Page 61 Lordship. Find on Lordship. Most probably. 25/11/2024 Lordship. So here in Lordship, the one document says annex Lordship is
Yes.
very contradictory. Very contradictory. Page number 61 Lordship, annexure 1. Lordship, finally find Lordship. So here in Lordship, Rajiv Gandhi LP Scholarship, the column number 1, 2, 3, 4, 5, 6 Lordship. So Rajiv Gandhi LP Scholarship. So here is the newly provincialized in the year of 2013-14 Lordship, is the academic year Lordship. So here in very contradictory Lordship, and the subsequent Lordship is a 1, 2, 3, 4, possibly 9, 10. Yeah, newly provincialized again, Mumtaz Begum 2016-17 Lordship. So here in Lordship, serial number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. It's a 2016-17 Lordship. So here in Lordship, the initially provincialized in the year 2013 Lordship. So after 1 year's Lordship, the provincialized has withdrawn Lordship due to the non-availability of the dice Lordship. So here in the document submitted my friend Lanet Council Lordship. So the SSA himself is Lordship, the newly provincialized in the year 2016-17. This document is very much contradictory, Lordship.
No, subsequently the school was provincialized.
Yes, Lordship. No, not Lordship. Cancellation order. Cancellation order I have challenged,
Okay.
Lordship.
No,
So
here it is mentioned that as a newly provincialized.
Yes, Lordship. File affidavit, Lordship.
Probably, my lord, it was not, my lord, uploaded, corrected in the website. Subsequently, my lord, unrecognized. Lordship, it's from 1780.
Yes.
So subsequently, this is a development from the department. It will go, my lord, to NIPA, then it will be uploaded. We have corrected it subsequently.
Lordship, the initial
It should not help him, my lord. After that, we have got the tax.
So the suspension Lordship, the one paragraph Lordship, I will raise this query Lordship. Paragraph number 4 is a judiciary Lordship, is a honorable. In as much as Lordship. Paragraph number 4 Lordship. So here is Lordship, the inadvertent mistake on the part of the district scrutiny committee Lordship. So inadvertent Lordship, last line Lordship, the paragraph number 4 Lordship. It being the so, we have to consider the reason the rejecting the provincialization of the petitioner school in the background of the approach had inadvertently mistake on the part of the district scrutiny committee Lordship. So there in Lordship, the district scrutiny committee has the mistake Lordship. So here in Lordship, the lots of the mistake in here Lordship, the my friend Lanet Council Lordship, the documents. So initially Lordship, the department himself stated, say in the year 2014, the dice code record 2019 are available Lordship. The subsequently again file they have to the dice code record is 2019 is not available. So Lordship is very contradictory, Lordship. So department himself initially stated, Lordship, the dice code record available, Lordship, that a particular school, Lordship. So basically, Annexure 6, page 37, the block limited education, Lordship. Is a admitted facts, Lordship. So section, evidence section, and Lordship, the section 24 of the 2017, the last occasion discussed in this regard, Lordship. So last time, maybe introducing it. Repeal and savings, Lordship, section 24, Lordship.
Page number?
Page number 126, Lordship. The 2017 Act, Lordship. Repeal
Yes.
and savings, Lordship. The last 3 line, Lordship. So the rules notification issued thereunder, the shall extend repeals. However, all the teachers whose services were provincialized prior 2023/9/2016 shall continue, and their cases shall be reviewed as per the eligibility norms set for the provincialized under this Act, Lordship. So prior 2016, Lordship. So on that way, Lordship. So here in Lordship, the 2013. So on that way, Lordship.
No, that's all right, but one of the criteria is that your dias code should be reflected in the year 2009 and 10.
10, Lordship, yes.
But that criteria is not fulfilled.
So Lordship, the department, the respondent 5, the BOs clearly defined, Lordship. The record are available 2019, Lordship. The subsequently,
No,
my friend.
you say, except this letter, you have nothing to demonstrate before this court that your school has dias data for the year 2009 and 10.
So Lordship, as per the Evidence Act, Lordship, once they admitted the fact, Lordship, the section 58 of the Evidence Act, Lordship, they clearly define, Lordship. If once they admitted the facts, it does not record the subsequently proof, Lordship. So Evidence Act clearly defined, Lordship. So here in Lordship, so BO himself is stated, Lordship, the 2019 record are available, Lordship. Okay, this is my respectful submission before the Honorable High Court, Lordship. The record are available, initially admitted, Lordship. And the judgment says, Lordship, the passed by this Honorable Court, Lordship. So herein inadvertently mistake of the district scrutiny committee.
No,
And
here it is not the mistake of the district scrutiny committee.
Yes. But here in direction, Lordship, the department should be considered in this regard, Lordship, in regard to the provincial Lordship. The last paragraph, Lordship, the 9, Lordship, the John Service, and blank that particular judgment, Lordship.
No, their name was there. In that case, the dias code was there for the year 2009 and 10. Though there are some mistake in that dias code.
So my case also the available, Lordship, that dice code record, Lordship, 2019. Now subsequently they have to project it. The dice code record is 2019 not available, but initially admitted, Lordship.
Anyway, heard Mr. Arcedas, learned counsel for the petitioner, Mr. Gogoi for the respondent number.
7.
Respondent number 7, Mr. Hopon for respondent number
1, 2, 3, 5, 4,
1, 2, 3, 4, and 5. 6. Argument concluded, judgment is at.
Master, right.
Coming as 35.
Meet, please, Your Lordship.
I appear on behalf of all respondents, Lordships. Now, Lordship, this is the RSA of 2025, Lordships. Lordships, on 10/11/2025, I submitted the Halafnama, Lordships. Lordships, I pray for little accommodation, Lordships. First week of August, preferable, Lordships.
But you could have mentioned the matter in the morning. She has been waiting till now, from morning on. And even you have been informed by the courtmaster, but you remain absent.
Lordship,
And now
during-
you are trying to.
Lordship, during admission hearing, his presence is required, Lordship, and Lordship, he has nothing to say in the admission. Admission is between court and the appellant, Lordship. And here, Lordship, they are the plaintiffs in para 2. They have mentioned that they are paying for 3 kathas of land, and the learned trial court has granted 1 bigha 3 katha 3 lesser, Lordship. So identification regarding and recovery is there, Lordship. I am praying for stay also, Lordship.
Again, if we grant you adjournment again on that day, you will remain absent.
Lordship, I undertake that on the next day, fixed Lordship, I will appear before the honorable court.
Whether any execution case is filed,
No, Lordship.
not
Not
filed.
yet filed,
So let us wait, let him,
Lordship.
but you have to remain present on that day,
Lordships.
Lordship, and then Monday, Lordship.
coming Monday.
Monday we have fixed some cases. So it's Lordships.
Wednesday,
Wednesday, Lordship.
okay. Heard
If
means
he
also
has
to the
any
learned
problem,
civil counsel
Lordship,
assisted by
F2 also he can.
Mr. R. Islam,
Kiba approval
learned
for
counsel for the appellant, Mr. Sharma for the respondent. Mr. Sharma has tried for little accommodation and he pressed for listing the matter in the first week of August. However, in view of the submission advanced by Ms. Sodori, learned counsel for the appellant, it is provided that the recess lays the matter on Wednesday, 29 July.
Thank you.